Hello students, today in our paper Labor Laws with paper code BBA07 we are going to cover the topic of third unit, that is the Workmen's Compensation Act 1923. We are going to learn about the object and definitions given under the act. I am Ragini Dikshit, working as Assistant Professor, School of Management, BBD University. Now the contents of this presentation are: first, introduction, then objective of the act, applicability of the act, to whom does this act applies, then definitions which are covered or given under the act, then finally the conclusion. Now, introduction. A beginning of social security in India was the passing of the Workmen's Compensation Act 1923. So, beginning of social security began from the Workmen's Compensation Act in India. In 1921, the government formulated some proposals for the grant for compensation and circulated them for opinion. The proposals received general support. As a result, the Workmen Compensation Act was passed in March 1923 and it was put into force on July 1, 1924. So it was passed in March 1923 and it came into force on July 1st, 1924. Subsequently, there were a number of amendments which were done to the act, and Workmen Compensation Act has been amended on 9th January 2010, and this Workmen Compensation Act is now renamed as the Employees Compensation Act, and wherever workmen or workmen is mentioned in the entire act, the same needs to be read as employee. So, workman can be called as employee. So, it can be called as the Employee Compensation Act. Now, what are the objects of the act? The Workmen Compensation Act 1923 is one of the important social security legislation, and it aims at providing financial protection to workmen and their dependents in case of accidental injury by means of payment of compensation by the employer. So, it is a social security legislation, and what does it do? It aims at providing financial protection to whom? To workmen and their dependents in case of accidental injury by means of how they are going to compensate, by means of payment of compensation. So, they are going to provide financial protection to the worker as well as to their dependent in case of accidental injury, and how they are going to compensate by means of payment of compensation. The act will be called the Employees Compensation Act 1923, and it extends to the whole of India, and as we know that it shall came into force on the first day of July 1924. Now, we can see in this diagram the objective of the act is to provide relief to workmen and their dependents if workman is dead or it is disabled, and this injury or his death or disableness arises from accident arising out of and in course of employment. Now, what do we mean by arising out of and in course of employment? We will learn in our subsequent presentations. Now, applicability of the act. It applies to all employees working in mines, factories, plantations, construction establishments, oil fields. All employees are covered under the act. Moreover, it applies to establishments which are under Schedule 2 of the Workers' Compensation Act. Now, the act applies to persons who are working abroad or outside India as per Schedule 2 of the act. It applies to person recruited as the mechanic, helper, driver, etc. in connection with a motor vehicle. This act applies to them also. It also applies to a captain or member of the crew of an aircraft. Moreover, the act does not cover the members of armed forces of the UNW who are already under Employee State Insurance Act. It does not cover those members of armed forces who are already covered under Employee State Insurance Act. So, it applies to all the employees working in mines, factories, plantations, oil field, working outside, abroad, or outside India, then any mechanic, helper, driver, or captain or member of the crew of or an aircraft. Now, scope and coverage of the Act, we can clear it out from this diagram. It extends to whole of India and it applies to employees employed in factories, mines, plantation, transport, establishments, construction works, railways, ships, circuses, and it does not apply to members of Armed Forces of Union, then employees covered by Employee State Insurance Act, then casual workers and workers employed otherwise, then for employers, trade or business, casual workers who are not permanent workers, and workers employed otherwise, then for employers, trade or business. So these are not applicable, these persons are not applicable for the privileges or for the provisions of this Act. Now, defenses available to employers before passing of Employees Compensation Act. This was a doctrine of assumed risk. This defense was available to employers, that is violenti non fit injuriam. Where there is consent, there is no injury. That is where there is consent of the employee and where as well as the employer, then there is no injuries. Then there was a doctrine of common employment. Employer not liable to pay compensation to employee for injury. Worker working with several persons for common purpose. For example, workers are working in group. Then worker injured by some act or omission of some of the person of his group. Doctrine of common employment, that in these cases employer was not liable before passing of Employee Compensation Act 1923. Then there was a doctrine of contributory negligence. It says that employee not entitled to compensation for injury caused by his own negligence. Employer not responsible for negligence on the part of the employee. So if an injury or an accident occurred because of negligence of an employee, then it will not the duty of the employer to pay compensation to the employee. Then end of personal action with death. Personal action of employee came to an end due to death of employee. So these are the defenses available to employers. So they can prevent themselves from, they prevented themselves from giving compensation to the employees by following these defenses before the passing of Employee Compensation Act 1923. Now, coming to the definitions, there are various definitions given under this Act, and these are your commissioner, compensation, dependent, the types of disablement, then your employer, employee. There are various definitions. We will do one by one. First is your commissioner. These definitions are given in section 2 of this Act, that is the Employee or the Workmen's Compensation Act 1923. Now, section 2(1)(b) defines the commissioner. Commissioner for employees compensation appointed under section 20. Definition is commissioner for employees compensation who is appointed under section 20 of this Act. Now, next is your compensation as provided by this Act. It is given in section 2(1)(c). Then comes the definition of the dependent. Who is dependent? It is given in the section 2(1)(d). Person who depends upon another for his livelihood. That is the general meaning of the dependent. Any person who is dependent on other for his livelihood will be called as dependent. Now, we can revise these definitions, like commissioner means a commissioner for employees compensation appointed under section 20. Then compensation means compensation as provided for by this Act. Now, coming to the definition of dependent. These can be dependents whether actually so or not, wholly dependent on the earning of the employees at the time of death, and dependents wholly or in part dependent on the earning of the employees at the time of death. So these are of dependents whether actually so or not, whether they are actually dependent or not. However, they are said to be the dependent on the employee for their livelihood. Then those persons who are wholly dependent on the earnings of the employee when his death occurred due to accident. Then dependents wholly or in part dependent on the earnings of the employee at the time of death. Now, dependents, whether actually so or not, they can be widow, then there can be minor, legitimate or adopted son. Minor, he is minor means he has not attained the age of 18 years, and he is legitimate or you can say legal or adopted son. Then unmarried, legitimate or adopted daughter or a widowed mother. They can be said as the dependent on the earnings of the employee. Then those persons who are wholly dependent on the earnings of the employee at the time of death, they are son or daughter who has attained 18 years of age and are infirm, they are not able to take their decisions by their own. Then dependents wholly or in part dependent on the earnings of the employee at the time of death. They can be widower, he can be a widower, parent other than a widowed mother, minor illegitimate son, that is minor and illegitimate illegal son, unmarried illegitimate daughter or daughter legitimate or adopted if married, and a minor or if widowed and a minor. Then minor brother or unmarried sister or a widowed sister if she is minor. Then minor child of a predeceased son. Then minor child of predeceased daughter where no parent of child is alive. Then paternal grandparent if no parent of the employee is alive. So they can be called as dependent on the livelihood, dependent on the employee for their livelihood. Now, coming to the revision side, that is dependent means any of the following relatives of the deceased, namely a widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter or a widowed mother. If wholly dependents on the earning of the employee at the time of his death, a son or a daughter who has attained the age of 18 and who is infirm. If wholly or in part dependents on the earnings of the employee at the time of his death, they can be a widower, a parent other than a widowed mother. Then a minor illegitimate son, an unmarried illegitimate daughter or a daughter legitimate or illegitimate or adopted if married, and a minor or if widowed and a minor. A minor brother or an unmarried sister or a widowed sister if a minor, a widowed daughter-in-law, a minor child of a deceased son, a minor child of a deceased daughter where no parent of the child is alive, and a paternal grandparent if no parent of the employee is alive. Now, coming to the definition of the employer. Employer includes any body of persons, whether incorporated or not, any managing agent of an employer, and the legal representative of a deceased employer. He can also be considered as an employer. So this definition of employer is given in section 2(1)(e), and it says that an employer includes any body of persons, whether incorporated or not, any partners, whether they were incorporated or not, then any managing agent of an employer, an agent who is working on the behalf of the employer, he will also be considered as employer for the payment of compensation. Then the legal representative of a deceased employer. The employer has deceased and his legal representative can act on his behalf. Now, coming to the disablement, we are going to do this part in detail also. First, let us discuss what is given in this slide. That is, disablement means loss of capacity to work or to move. Disablement of an employee may result in loss or reduction of his earning capacity. Means disabled means he becomes disabled, means he lost his capacity to work or to move. Then disablement of an employee may result in loss or reduction of his earning capacity. When he is not able to do work, or if he is not able to move, then it may result in loss or even reduction of his earning capacity. that is not able to earn as much as worker used to earn before his disablement. That is, if he before disablement he was able to earn rupees 200, but after that disablement he is able to earn just rupees 100. Now we can revise this definition, that is employer includes any body of persons whether incorporated or not, and any managing agent of an employer and the legal representative of a deceased employer. So an employer include any body of persons whether incorporated or not, then managing agent of an employer, and then the legal representative of a deceased employer. When the services of an employee are temporarily lent or lent on hire to another person by the person with whom the employee has entered into a contract of service or apprenticeship, means such other person while the employee is working for him. That is, when the services of employee are temporarily lent or lent on hire to another person by the person with whom the employee has entered into a contract. For example, he comes to work under one employer, and that employer transfers that employee to another employer. Then the other employer will be responsible for paying the compensation to the employee. Now, disablement. Disablement of employee may result in loss or reduction of his earning capacity. Then your disablement can be partial disablement or total disablement. This partial disablement can be temporary partial disablement or permanent partial disablement. And this total disablement can also be temporary and permanent. Now, disablement means an employee may result in loss of or reduction of his earning capacity. He is not able to earn as much as he was before that disablement has happened. Now, this disablement can be partial disablement as well as your total disablement. Partial disablement reduces earning capacity of the the earning capacity has not been lost. Partial disablement reduces earning capacity. Now this partial disablement can be temporary partial disablement as well as your permanent partial disablement. Now coming to the temporary partial disablement. Temporary partial disablement means it reduces earning capacity of an employee in any employment he was engaged at the time of accident. So the type of work in which he was engaged at the time of accident, in the same type of work it reduces his earning capacity. Now coming to permanent partial disablement, it reduces earning capacity of an employee in every employment. There is a minute difference, that is in temporary partial disablement the employee reduces his earning capacity in the same type of service or in same type of employment, while in permanent partial disablement the employee reduces his earning capacity in every type of employment. Now coming to total disablement. Total disablement can also be temporary total and total permanent disablement. It incapacitates an employee for all work he was capable of performing at the time of accident. All work it can be either any employment or it can be every employment. That is total disablement. Total incapacitates an employee for all work he was capable of performing at the time of accident. Now, this temporary disablement means disablement in doing normal work continuous for a temporary period. Temporary disablement is subdivided into following two heads as we have done earlier: temporary total disablement and temporary partial disablement. Temporary total disablement incapacitates a workman to do every work which he could do. It lasts for the temporary period. Temporary partial disablement reduces the earning capacity of workman in doing every work which he could do well before the accident. It also lasts for a temporary period. Then coming to permanent disablement. Permanent disablement means disablement arising out of the accident. It lasts forever, for example, permanent in nature, and it is as we have done temporary disablement, either it is permanent, either it is total or partial, it is temporary. But in permanent disablement, it is temporary, or it can be temporary, it can be total, or it can be partial, but it is permanent. Permanent disablement means disablement arising out of the accident and it lasts forever. For example, permanent in nature. And it is subdivided under the following two heads. These are permanent total disablement and permanent partial disablement. If employee as a result of an accident suffers from injury specified in part 1 of schedule 1 in the Workmen Compensation Act 1923. There are various schedules related to types of disablement, how to calculate compensation, then what are the occupational diseases. There are various schedules in which description of these disablement types or occupational diseases type is given. So these are the schedules. In part 1 of schedule, in the subsequent slides I will show you what is part 1 or schedule 1. Or suffer from such a combination of injuries specified in part 2 of schedule 1 as will bring the loss of earning capacity when total to 100%, or more such an injury is said to be permanent total disablement. To determine whether the injury is permanent or temporary, the total effect of injury on the employment opportunities of the employee concerned is the deciding criteria. In simple words, the accident in capacity is loss of 100% earning capacity forever. For example, permanent in nature. Injuries are listed in part 2 of the schedule 1 reduces 100% earning capacity forever. For example, loss of both hands, that is 100%. Loss of one hand, 1 foot, disfigurement, absolute deafness, etc. Then coming to permanent partial disablement. Permanent partial disablement reduces earning capacity in every work which he could do well. It is permanent in nature and every injury scheduled in part 2 of schedule 1 is deemed to be permanent partial disablement. Example, loss of thumb 30%, loss of 4 fingers of one hand 50% is given in the schedule 1 part 1 part 2. Permanent total disablement and permanent partial disablement is decided on the basis of schedule 1, whether it is given in the schedule 1 in part 1 and part 2 of schedule 1. Now you can see schedule 1 and part 1, that is your permanent total disablement. That is 100%. Percentage of loss of earning capacity is 100%, and it can be loss of both hands or amputation at higher side, loss of a hand and a foot, then a double amputation through leg or thigh, then loss of sight to such an extent as to render the claimant unable to perform any work for which eyesight is essential, then very severe facial disfigurement, absolute deafness. All this include 100% loss of earning capacity, and these injuries are given in schedule part 1 of schedule 1. Now, the injuries which are listed in part 2 of schedule 1 are your amputation through shoulder joints 90, amputation below shoulder with stump less than 80%. These are the percentage of loss of earning capacity. So, depending on part 1 and part 2, the permanent or your temporary disablement, permanent partial disablement, or permanent your total disablement is decided. That is, permanent total disablement and permanent partial disablement is decided on the basis of type of injury which is caused to the employees, whether it is given and it is specified. These types of injuries are specified in schedule 1 part 1 and part 2, that is part 1 and part 2 of schedule 1. Now, coming to the next definition, that is of an employee, means a person who is a railway servant as defined in clause 34 of section 2 of the Railways Act 1989, not permanently employed in any administrative district or subdivisional office of a railway, and not employed in any such capacity as is scheduled in Schedule 2. He can be a master, means a railway servant, then a master, seaman, other members of the crew of a ship. He can be a captain or other members of a crew of an aircraft. A person recruited as a driver, helper, mechanic, cleaner, or in any other capacity in connection with a motor vehicle, he will also be considered as a employee. Then a person recruited for work abroad by a company and who is employed outside India in any such capacity as it is specified in Schedule 2, and the ship, aircraft or motor vehicle or a company, as the case may be, is registered in India. He will also be considered as employee under the Workmen Compensation Act. Now, employed in any such capacity as is specified in Schedule 2, whether the contract of employment was made before or after the passing of this Act, and whether such contract is expressed or implied or oral. Now we can see, or we can revise the definition of employee. It is given in section 2(1)(n). He can be a railway servant who is not permanently employed in any administrative district or subdivisional office of railway and not employed in capacity as specified in Schedule 2, but he will be considered as a employee. Now, he can be a master, seaman, and other members of a crew of a ship. He can be captain or other member of a crew of an aircraft. He can be driver, helper, mechanic, cleaner, or in any capacity in connection with motor vehicle. He can be person recruited for work abroad by a company, employed outside India in any capacity specified in Schedule 2. He can be working on ship, aircraft, motor vehicle, company which is registered in India, employed in any capacity as specified in Schedule 2. And it does not include, employee definition does not include employment of casual nature. Casual nature means not regular or continuous employee. Now, let us learn what do we mean by managing agent. This definition is given in section 2(1)(f) of the Workmen's Compensation Act, and it says that managing agent means any person appointed or acting as the representative of another person for the purpose of carrying on such other person's trade or business, but does not include an individual manager subordinate to an employer. Now, coming to the definition of minor. Minor means a person who has not attained the age of 18 years. Prescribed, according to given in section 2(h) of this Act, prescribed means prescribed by rules made under this Act. Now, qualified medical practitioner, given in the section 2(i) of this Act, means any person registered under Central Act, Provincial Act, or an act of the legislature of a state providing for the maintenance of a register of medical practitioners, or in any area where no such last mentioned act is in force. Any person declared by the state government by notification in the official gazette to be qualified medical practitioner for the purpose of this act. Wages. Wages include any privilege or benefit which is capable of being estimated in money, other than a travelling allowances or the value of any travelling concession or a contribution paid by the employer of an employee towards any pension of provident fund, or sum paid to an employee to cover any special expenses entailed on him by the nature of his employment. Now, coming to the occupational disease. What is occupational disease? This definition is given in section 3 of this Workmen Compensation Act, and it says that an occupational disease is any chronic ailment that occurs as a result of work or occupational activity. That is, it can be any chronic ailment, and why it occurs as a result of work or occupational activity. It is an aspect of occupational safety and health. An occupational disease is typically identified when it is shown that it is more prevalent in a given body of workers than in the general population or in other population. That is, occupational disease is generally identified. How it is identified? Through its prevalence. It should be more prevalent in body of workers who are working in that particular occupation than the general population. Then, if any injury or disease is caused which is specified in Part A, Part B and C of Schedule 3, it shall be deemed to have been an occupational disease or injury arising out of and in the course of employment. Now, what do we mean by this arising out of in the course of employment? We will do in our subsequent presentations. Enabling the employee to claim compensations. Whatever diseases as specified in Part A, B, C of Schedule 2 are covered under the occupational diseases. Now, thus the Schedule 3 is divided into Part A, B and C in the following manner. If an employee employed in any employment specified in Part A of Schedule 3 contracts any disease specified therein, it shall be presumed that such disease is occupational disease peculiar to that employment. For this, no length of service is prescribed. If an employee is employed in any employment specified in Part B of Schedule 3 for a period of 6 months and attracts any disease specified therein, it shall be presumed that such disease is occupational disease. So, that disease should be present in the Schedule 3 Part A, Part B and Part C, and there are a specific period which is required for calling that disease to be occupational disease. Now, if an employee is employed in any employment specified in Part C of Schedule 3 for a period as is prescribed by the central government attracts any disease specified therein as occupational disease, it shall be deemed to be an injury peculiar to that employment. So, these three criteria are given for the Part A, Part B, Part C occupational diseases given in the Schedule 3 of the Workmen Compensation Act 1923. Now it is called as, it has been amended and now it has been called as the Employee Compensation Act 1923. Now, these are the list of occupational diseases given in Part A. Part A contains diseases like infectious and parasitic diseases contracted in an occupation where there is a particular risk of contamination, disease caused by working in compressed air, diseases caused by lead or its toxic compounds, then poisoning by nitrous fumes, poisoning by organophosphorus compounds, that is, these are chemical poisons, all employment, all work involving exposure to contract in occupation, health or laboratory works, all work involving exposure to the risk concerned. So, all these will be considered as your occupational diseases given in Part A. Similarly, there are diseases given in Part B. These are classified in Part B of these of your Schedule 2, that is diseases caused by phosphorus or its toxic compounds, mercury, benzene, nitro, chromium, arsenic or radioactive substances. Then there are various diseases which are classified in your Part C of Schedule 2 of the Workmen Compensation Act. These are your pneumoconiosis caused by sclerogenic mineral dust and silico-tuberculosis, provided that silicosis is an essential factor in causing the resultant incapacity or death. It is somewhat similar to your TB, tuberculosis. Then brucellosis, these are the various diseases, names of diseases. This is bronchopulmonary, that is the diseases of lungs, extrinsic allergy. Then bronchopulmonary disease caused by hard metals. So, exposure to these fumes or these gases can cause various occupational diseases to the workers or employees working in or exposed to such environment. So, this was all about your Workmen's Compensation Act, and we have covered today the object and the various definitions given under the Act. In our next presentation, we are going to cover the employer's liability for compensation, how much that employer is liable, in which conditions he is liable. Now, thank you class.